Ladies and gentlemen, good morning, good afternoon, or good evening. Wherever you are in the world, we appreciate you being with us right now. This is Lovely Life, a Dome podcast. Dome is a digital and bilingual media company specialized in law at the supranational level. So, for all news, comments, analysis related to law in Africa and in the rest of the world, go to our website dome-online.com and follow us on our social media platforms, the links of which are listed below. This, however, is neither a technical nor a political podcast. To be honest, sometimes it's barely a legal one. The only prerequisite needed is to have an open mind and 30 minutes or so to spare. We sometimes will have guests from everywhere around the world, and we will always be keen to hear your thoughts. We have a fantastic episode for you today, so please stay with us and weigh in while we argue the case. Lovely Life. In today's episode, we are going to talk about free speech. It was inevitable, wasn't it? But, to be honest with you, I really did not want to do this episode because the concept has been tackled from virtually every angle, and I really did not see what this program would add to the conversation. But, common sense prevailed, because if there ever was a legal notion that has been used, abused, and yet misconstrued by people, it certainly is free speech. So, I will try my best not to fill the remaining time with platitudes. But we have to start somewhere. So, let's start by stating the obvious. Freedom of expression is one of the most fundamental and most protected of human rights. It is, as we are going to see, enshrined in virtually every international instrument and is a constitutional right almost everywhere around the world. Social media, though, has certainly pushed the boundaries of what free speech means now. It is important, however, to remember that social media is a double-edged sword. On the one hand, it could be used as a fantastic vehicle to bring to the forefront issues that are near and dear to someone's heart, but that may not be on the front pages of newspapers around the world, for example. As cliché as it sounds, it can create and foster a community, and even, albeit not often, generate a real change in people's lives. We sometimes forget it, but it does happen, and it needs to be appreciated. Now, on the other side of the coin, if we look at the intersection of social media and free speech, we can see that there has certainly been, in the last 2 decades, an appropriation of the concept of the truth. That is why you hear people say more and more often that they want to say and they want to tell their truth, which is quite odd when you think about it for a second. You see, the truth is not plural. The truth is not personal. It is not a truth. It is not one's truth. In actuality, there is the truth, and there is one's feelings or opinion that one is allowed not only to have, but to express. This gives me the opportunity to make the very important distinction between freedom of opinion and freedom of expression. It is sometimes used synonymously, and one can understand why. Because for most people, it is a logical process. One first thinks something and then expresses it. This also explains why, in most international treaties and conventions, both freedoms are dealt with one after the other. Let's cite as examples the Universal Declaration of Human Rights, Article 19, or the African Charter on Human and People's Rights, Article 9, among others. All these instruments are obviously available on our website, dome-online.com, in the treaty section. To come back to the point at hand, using both terms of freedom of opinion and freedom of expression interchangeably is, however, neither technically nor legally correct, and can have very important legal ramification. You see, on the one hand, we have the freedom of opinion, which is a right, and please hear me when I say this, that is absolute and cannot be restricted. And, on the other hand, there is freedom of expression, that is a very encompassing right, but not quite absolute. To be clear, it is not enough for someone to express an unpopular opinion for his or her freedom of expression to be restricted. In fact, lawyers will tell you that it is precisely because one's opinion is unpopular and or uncomfortable that it must be protected. It is in fact why the right exists. Any restriction to the freedom of expression must be provided by law, undertaken to respect the right or reputation of others, protect national security or public order, protect public health or moral, and must be necessary and proportionate to achieve a legitimate objective. The language may vary from one country to the other, but these are essentially the standards that exist in international law and are codified at the national level. Now, with that in mind, we can start to look into famous cases where free speech was alleged and why it was denied. There are a lot of legal angles we could choose to explore. I thought that it would be interesting to look at them from the point of view of the interest to act and challenge the freedom of speech. You're going to see what I mean in a minute. The first situation for which free speech is lawfully restricted is the respect of either the right or reputation of others. Let's start with the latter, the protection of reputation. That is, basically, if you think about it, the foundation for defamation law. To be clear, one is allowed to say whatever one wants, up to the point, and it is crucial, that it does not unduly damage the good name of someone else, either through slander or libel. In that case, of course, because the damage is personal, it is only for the person whose reputation has been tainted to try and restore it. That person can ask, for example, for a retractation using the same means the alleged defamatory statements were made. A more contentious approach is, of course, available. The alleged victim of defamation can file a civil lawsuit and try to make his or her case in court. Let's take as an example the case John Christopher Depp II versus Amber Laura Heard, which is the most talked about case of this year in the United States. For those who have not followed it, both parties are actors and were married from February 2015 to 2017. From the myriad of interviews given, mostly by Ms. Heard, and testimonies of both parties in court, to say that the marriage was tumultuous and unhappy is an understatement. Allegations of affair, drug abuse, violence were made by both parties. After the divorce was finalized, Ms. Heard became an advocate for domestic abuse and notably wrote an op-ed in 2018 for the Washington Post titled, and I quote, "I spoke up against sexual violence and faced our culture's wrath. This has to change." End of quote. In other words, she thought that she was exercising a right to free speech. Though she did not mention Mr. Depp by name, there was little doubt who she was referring to, and it is on that basis that her ex-husband, Mr. Depp, filed a lawsuit for defamation before a Virginia court. After a trial that was followed eagerly by everyone, me included, I must be honest, the jury found in favor of the plaintiff, Mr. Depp, on all 3 counts of defamation and awarded him a total of $15 million, which was reduced to 10.3 million because of legal limitations. Ms. Heard won on one count, stating that statements made by Mr. Depp's lawyer were defamatory towards her, and was awarded 2 million. In this case, the versions of the ex-spouses were so widely different that they could not be reconciled. Someone is lying. No middle ground could be found, and supporters of each camp are still, to this day, fighting on social media, relitigating a case that was properly dealt with in a court of law. To be exhaustive and explain the reason why I cannot yet call this matter legally settled, it must be stated that Ms. Heard filed an appeal, followed in the process by Mr. Depp, and that the matter is pending. No brief has been filed yet, but there is a high possibility that the appeal centers around free speech. So, we will see how that goes in the coming years. Talking now about the protection of one's rights. The logic is pretty much the same. It is for the person or the family of the person whose rights have been breached to ask for reparation. An example we can take is the case of the allegations made by Alex Jones following the Sandy Hook Elementary School shooting that happened in 2012. There is a lot to be said about Alex Jones. Suffice to say, for now, that the man is a conspiracy theorist who runs a really popular website and appears in various programs. In this particular instance, what happened was that on December 14, 2012, Adam Lanza, the perpetrator, fatally shot his mother before murdering 20 children and 6 staff members at the Sandy Hook Elementary School in Newton, Connecticut, and later committed suicide. Alex Jones, among others, went on his shows and other programs, exercised what he believed at the time to be his right to free speech, and openly doubted that the tragedy ever occurred, or that at the very least, if there had been indeed a shooting, no one had died. And he called the victims, quote, child actors, end of quote. That is disinformation. That is peddling objectively false information to suit one's personal agenda for whatever reason. And it is very important to state that Mr. Jones has been banned from almost every social media platforms. In April 2018, the first of many lawsuits regarding these incredible allegations were filed by parents of victims in both Texas and Connecticut against him and his companies. During his testimony under oath in 2019, he finally admitted that the murders were real, stating that he had, quote, almost like a form of psychosis, where he basically thought everything was staged, end of quote. The admission was not enough, and the trial moved forward. Without going into legal details, the defamation lawsuits that were tried were successful. The question of a reparation is being addressed by the courts of Connecticut as we speak, whilst he has already been ordered to pay $49.3 million for the trial in Texas. So far, this is fairly clear. Someone feels his or her reputation or rights have been breached or attacked by something that has been said, and they have an interest to see it rectified or at least receive compensation for it. The last block of exception for which free speech can be lawfully curtailed is the protection of national security, public order, public health, and/or morals. As a protector and regulator of the social fabric as a whole, it does make perfect sense that the protection of these fundamental interests would primarily fall onto the state. And by the way, since we're at it, It usually occurs before a judge. A prosecutor or a party files a lawsuit against someone, a case is tried, and justice is hopefully served one way or the other. But there are instances where the impulsion comes from another branch of the government. For example, the executive one. We can take as a case study the case of the Imam Hassan Iquiesen, that is a French national of Moroccan descent. He was accused of making remarks that, quote, were contrary to the values of the French Republic, end of quote. An expulsion decision was issued by the French authorities in July 2022. But he vanished the following month, triggering the issuance of a European arrest warrant for evading the execution of a deportation decision. He has been apprehended last September in Belgium and awaits the next step in his procedures, meaning being deported either back to France or directly to Morocco. This is one instance where states combat hate speech, misogyny, and anti-Semitism. States have an interest to maintain social peace and take appropriate measures to do so, up to and including curtailing the very fundamental freedom of expression in a lawful, proportionate, and necessary fashion. I think it's pretty straightforward. The interesting legal phenomenon in the last 5 years is that major media companies such as Twitter, Facebook, or YouTube, through their policies, can suspend, demonetize, or even deplatform people they feel do not abide by their guidelines, which is essentially restricting free speech. The problem with this is obvious, is it not? The problem is they are private entities. And yes, as such, they get to decide what is acceptable on their platforms. But again, you have to understand, not every right is made equal. At the top of the pyramid sits the freedom of expression. If you are to restrict it, you need to prove that 1. The speech or declaration made falls within one of the very narrowly construed exceptions that we have talked about, and 2. That you have an interest to do so. So, this begs at least 2 questions. And mind you, those are only questions. I do not have the answer. If you do, please do let me know. I would love to hear from you. The first question is a fairly logical one, if you have followed things up to this point. Taken from a legal point of view, what is the interest of these huge corporations to suspend, demonetize, deplatform, or cancel some users and not others? If your reputation is tainted because of statements made by someone else, you have an interest to initiate a defamation lawsuit. If there is a statement or a speech that promotes heinous acts or division, groups that are targeted and states have an interest to initiate proceedings. What is the interest of this huge corporation? The answer may be that they too protect the fundamental interest of national security, public order, public health, and whole morals. One could make that argument, actually. But when you look at it, it does not really hold up. Because the main objection would be that it is the purpose and the main mission of a state to do so. If these huge corporations have been deputized, quote unquote, by the states to police free speech around the world, then states need to come out and say so. Inform the public at large that the duty of protecting the freedom of expression, like so many others before it, has been privatized and is no longer incumbent to the state. Barring that, as long as it is not clearly stated, one struggles to understand what is the legal, and I insist, legal interest that companies have to take the measures that they do in some instances. The second issue with this is, of course, that some decisions look both concerted and arbitrary, don't they? In the last 2 weeks, we have had decisions that we believe should be cause to pause for anyone, and certainly for any lawyer who believes in individual rights. We're going to take a couple of examples. The US payment giant, PayPal, has shut down the accounts of some of its consumers over the past week, most notably those of Us For Them, which is a group based in the UK that campaigned to keep schools open during the pandemic. Another group was Law of Fiction, which is a group of lawyers who had challenged lockdown, and Free Speech Union and its founder, Toby Young. The reason given for the termination of these accounts was that these accounts did not comply with PayPal's acceptable use policy. End of quote. When pressed, most notably by Toby Young, a spokesperson for the company stated that, quote, it could not comment on an individual customer's account and that PayPal regularly assesses activity against our long-standing acceptable use policy and will discontinue our relation with account holders who are found to violate our policies. End of quote. As a private company, they are certainly within their right to do so. But, let's admit it, it does not look good. The account closed either questioned and or promoted generally unpopular points of view. And because of its lack of transparency, the company has now opened its door to critics who feel that they are being censored. Another interesting case is that of the YouTube channel of Russell Brand. Initially, Mr. Brand made a video aiming at changing the narrative against COVID. Those are his words. And in that video, he cited information taken on government websites, but that he misinterpreted. He then, on his own accord, made another video recognizing his error and apologizing for any confusion that may have caused. This was not enough for YouTube, who took down the first video for breaching the community guidelines in spreading misinformation. Russell Brand then took down the apology video and relocated to another platform. As we record this, I think this is where we stand. At this point, I have to make the usual disclaimer, but it is a very important one. We are not opining on the substantive issues that are debated here. Mr. Brown, Mr. Young, the founders of Law or Fiction, or the founders of Us For Them, are more than entitled to be skeptical of some of the decisions made, and other people are more than entitled to disagree with their position there. This is not where the legal issue lies. We have Mr. Jones, that is a conspiracy theorist who disinforms people on the one hand. We then have Mr. Brand, who misinformed people unwillingly, as made clear by his second video that he made before YouTube took down the first one. And we have organizers of Us For Them who hold unpopular opinions. Do you see the gradation? Do you see the slippery slope we are looking at? There is willful disinformation, Alex Jones, accidental misinformation, Russell Brand, and uncomfortable views, Toby Young. And yet, they are all treated the same, without a clear explanation as to why they have been deplatformed. This is a problem when we have a private entity which legal interest is not clearly stated, because this legal person can be accused of censoring certain viewpoints to fit its political agenda under the guise of its policies. And given that they do not have to systematically explain their decisions, the question must be asked, can we speak our mind? since companies could in fact censor people basically as they wish. This is bad. In fact, that is dramatic because, as we have said, the restriction to the freedom of speech must be extremely narrowly construed, lawful, necessary, and proportionate. But, as bad as it sounds, the worst case scenario could be that it is no longer, or not only, the freedom of speech that is targeted, but rather the freedom of opinion, which, if you remember what we have said at the beginning of this episode, is absolute. When we look at the situation of the creators that are vigorously challenging the state's position when it comes to COVID mandate, or the teaching of gender theory to children in school that are being deplatformed, whether one agrees with them or not, and in my particular case, I must say that I don't have the medical or psychological training to make an informed decision at this time, and I'm trying to document myself more on the subject. I am worried, and you should be worried too, because at this stage, we are still learning about the COVID-19 disease and the best way to treat it, and we are still learning about how to best address, moving forward, the question of gender in society and in schools. To seemingly deplatform someone because they question or challenge the not yet settled consensus is legally and morally wrong. And we all, regardless of our personal beliefs, should be opposing this because it rains on every roof. And God forbid someday we get the same treatment for something we sincerely believe is right. Thank you so much for being with us today. I want to hear what you have to say. Do you have any comments? Question? Does it make sense? Does it not? Leave a comment below the link of the episode on our social media platforms using the hashtag #LoveyLife. The transcript of the program will be available on DOM's website in both French and English. If you have enjoyed this episode, please consider sharing, liking it, and subscribing to the show. We have had some great episodes previously, and we would be very grateful if you would consider listening to them. We will be back with our next episode next Wednesday. In the meantime, please stay safe and take care of yourself.